What happens when the most powerful institutions tasked with delivering justice become the subject of public mistrust? When does transparency turn into theater? And at what point does the release of millions of documents create more questions than answers? These are not abstract philosophical puzzles. They are the real dilemmas facing Americans as they try to make sense of what may be the largest document disclosure in Justice Department history. Over 3 million pages related to the investigation of convicted sex offender Jeffrey Epstein. On January 30th, 2026, the Department of Justice released this massive tranche of files under pressure from Congress, which had passed the Epstein Files Transparency Act the previous November. The law gave the Justice Department a deadline to disclose everything in its possession related to Epstein's crimes, his associates, and the federal government's investigation spanning nearly 2 decades. What emerged from that release has rattled governments, businesses, and prominent figures across the world. It has also exposed what many see as a pattern of selective protection, heavy-handed redactions, and a fundamental failure to provide the accountability that survivors of Epstein's crimes deserve. The files contain FBI interview records, internal agency communications, thousands of images and videos, email correspondence, financial records, and tips submitted by the public to the FBI's National Threat Operations Center. They document the scope of Epstein's criminal enterprise, a systematic operation that used private planes, luxury residences on multiple continents, and a network of enablers to facilitate the sexual exploitation of minors and young women over decades. But they also reveal something perhaps more troubling: how law enforcement received numerous credible leads about potential co-conspirators and chose not to pursue them, how prosecutorial decisions appeared to protect powerful individuals, and how even now, in the name of transparency, the government seems to be obscuring as much as it reveals. Among the millions of pages, one name appears more than any other. President Donald Trump is mentioned over 1,000 times in these documents. Some references are mundane: news articles Epstein collected, social event photographs, business correspondence that amounts to nothing more than evidence that 2 wealthy New Yorkers in the 1990s moved in overlapping circles. But buried within the avalanche of paper and digital files are documents that raise more serious questions. There are FBI records detailing unverified allegations of sexual misconduct. There are witness statements from women who describe encounters involving Trump at Epstein-related events. There is a 2019 FBI interview with a former Palm Beach police chief who recounted a phone conversation with Trump shortly after the Epstein investigation became public. The Justice Department has been careful to note that being mentioned in these files does not constitute evidence of wrongdoing. Deputy Attorney General Todd Blanche emphasized this point during a press conference announcing the release, stating that many documents contain untrue and sensationalist claims submitted to the FBI, particularly around the 2020 election. The department's own statement accompanying the release explicitly says that if any allegations against Trump had credibility, they certainly would have been weaponized against President Trump already. Trump himself has never been charged by law enforcement with any crime related to Epstein and has repeatedly denied any wrongdoing. He has stated publicly that he ended his relationship with Epstein in the early 2000s after concluding that he was, in Trump's words, a creep. These disclaimers are important. In an era of weaponized information and politically motivated allegations, skepticism about unverified claims is not just reasonable, it is necessary. The FBI receives thousands of tips on high-profile cases, many of which turn out to be false, exaggerated, or impossible to substantiate. The presence of an allegation in a file does not make it true. Law enforcement must investigate leads, but the failure to bring charges after investigation often means the allegations lacked sufficient evidence to proceed. Yet the existence of these documents, their volume, and the nature of some of the allegations they contain have created a situation where questions persist regardless of prosecutorial decisions. One document that has drawn particular attention is an FBI spreadsheet compiled in August 2025 that summarizes 16 complaints made to the FBI's National Threat Operations Center. 13 of these 16 complaints mention Trump personally. The allegations range from claims of sexual assault decades ago to accusations of participation in organized sex parties involving minors. According to the spreadsheet, at least 8 of the 16 complainants did not provide contact information when they made their reports. The FBI notes indicate that some individuals were reporting secondhand information and that many leads could not be corroborated or were deemed not credible after investigation. Another document describes an FBI interview conducted in July 2019 with a woman who alleged that she was sexually abused by Epstein when she was a teenager. During that interview, investigators showed the woman a photograph that included both Epstein and Trump. According to the FBI write-up, when asked about the photo, the woman said she wanted to crop Trump out of it before it was shared. Her attorney told investigators that the woman was concerned about implicating additional individuals, and specifically any that were well known, due to fear of retaliation. The woman advised FBI agents that Trump was someone she had met, but provided no further information. The specific allegation that Trump had sexually abused this woman does not appear in the interview record itself, though it does appear in the August 2025 spreadsheet summary, where it is listed among the tips received by the FBI's National Threat Operations Center. Perhaps the most discussed document is an FBI form detailing a complaint from an anonymous woman who accused Trump of raping her when she was 13 years old. This accuser had previously filed civil lawsuits against Trump and dropped them, with the final one withdrawn right before the 2016 presidential election. The FBI document details multiple instances of alleged abuse, including claims that Epstein was angry that Trump was the one to take Doe's virginity and also raped her. The anonymous accuser was scheduled to appear at a press conference in Los Angeles in November 2016, but the event was abruptly canceled. Her attorney at the time, Lisa Bloom, said her client was too afraid to show up. When asked for comment after the recent file release, Bloom declined, stating she was no longer representing the woman. These are not easy matters to discuss or assess. Allegations of sexual violence, particularly involving minors, deserve to be taken seriously. Survivors of abuse face enormous psychological, social, and sometimes physical barriers to coming forward. The fear of not being believed, of facing retaliation, of being publicly scrutinized, these pressures are real and well documented. When someone makes an accusation and then withdraws it, that does not automatically mean the accusation was false. It may mean the survivor was not ready to face the ordeal of a legal process or feared the consequences of proceeding. At the same time, American jurisprudence is built on fundamental principles: the presumption of innocence, the right to confront accusers, the requirement that guilt be proven beyond reasonable doubt. These principles exist to protect all of us from false accusations and miscarriages of justice. When allegations surface but are not pursued by prosecutors, when lawsuits are filed and then dropped, when witnesses cannot be located or refuse to provide details, these circumstances make it impossible for the public or the media to reach definitive conclusions about what actually happened. What we are left with then is a set of documents that raise questions but provide few answers. And that ambiguity has created a volatile situation where different interpretations proliferate depending on one's political perspective and prior assumptions about the individuals involved. The controversy extends beyond the specific allegations. There is also the question of what the FBI and Justice Department knew, when they knew it, and what they chose to do with that information. In August 2025, FBI officials in New York compiled an internal slideshow that included references to allegations involving Trump. It is not clear why this slideshow was created or what its purpose was. The document surfaced in emails sent by officials in the FBI's Child Exploitation and Human Trafficking Task Force. The timing is notable. This was months before the presidential election and during a period when the FBI was under intense scrutiny regarding its handling of politically sensitive investigations. Members of Congress who have viewed unredacted versions of the files have raised questions about whether law enforcement adequately investigated leads. Republican Representative Thomas Massie of Kentucky stated after reviewing documents that the files raised questions about whether FBI Director Kash Patel had given false testimony. In September 2025, before the files were released, Patel testified before Congress that there was no credible information that Epstein had trafficked young women to anybody other than himself. None, Patel said emphatically. If there were, I would bring the case yesterday that he trafficked to other individuals. After viewing the unredacted files, Massie suggested this testimony may have been inaccurate. Patel also testified in that same hearing that Trump's name appeared in the Epstein files fewer than 100 times. When specifically asked whether Trump's name appeared 1,000 times, 500 times, or 100 times, Patel denied each figure. I don't know the number, but it's not that, he said. Yet CNN and other news organizations have since reported that Trump appears in the files more than 1,000 times when the database is searched, though some results are duplicates. The contradiction between Patel's testimony and what the files actually contain has fueled criticism that the FBI director misled Congress. Though Patel defenders argue he may not have had complete information at the time of his testimony, or may have been referring to specific categories of documents rather than total mentions. Regardless of the explanation, the discrepancy has damaged public confidence in the Justice Department's handling of the matter. There is also the troubling question of why certain individuals appear to have been investigated while others were not. One document that has garnered significant attention is a summary of a 2019 FBI interview with Michael Reiter, who served as Palm Beach police chief from 2001 to 2009. Reiter told FBI agents that Trump had contacted him about the Epstein investigation, though the exact timing of the call is unclear. According to the interview summary, Trump called the Palm Beach Police Department to tell him, "Thank goodness you're stopping him. Everyone has known he's been doing this." Trump told him people in New York knew Epstein was disgusting. Trump said Maxwell was Epstein's operative, she is evil, and to focus on her. This account presents Trump in a very different light than the allegations of wrongdoing. It suggests that Trump, upon learning of the investigation into Epstein, expressed relief and indicated he had been aware of Epstein's misconduct. It also suggests Trump specifically directed law enforcement attention toward Ghislaine Maxwell, Epstein's accomplice, who was eventually convicted and is now serving a 20-year prison sentence. White House Press Secretary Caroline Leavitt, when asked about this document, said she could not confirm whether the 2006 phone call took place, but emphasized that, unlike many other people who are named in these files, President Trump cut off his relationship with Jeffrey Epstein and was honest and transparent about that for years and years. The timing and circumstances of Trump's break with Epstein have been the subject of much speculation and conflicting accounts. Some reports suggest the two men had a falling out over a real estate deal. Others suggest Trump distanced himself after becoming aware of Epstein's behavior toward young women. What is documented is that by the mid-2000s, their social relationship appears to have ended, years before Epstein's 2008 conviction. The release of these files has created intense public debate, but it has also created real harm for Epstein's victims. Multiple survivors and their attorneys have stated publicly that the Justice Department did an inadequate job protecting their identities in the document release. Despite assurances that victims' privacy would be protected, lawyers representing survivors say the latest batch of files exposed many of them, revealing personal information that was supposed to remain confidential. At least one woman who had not previously come forward publicly with abuse allegations was identified in the documents. Survivor Danielle Bensky stated that what she believed were confidential conversations with FBI investigators about Epstein were included in the document dump. Lawyers representing victims said they had been assured before the release that there would be no repeat of the privacy violations that occurred in earlier document releases, yet those violations happened again. For these women who have already endured immense trauma, having their identities and deeply personal details of their abuse made public represents a new violation, one committed not by Epstein, but by the very government institutions that were supposed to protect them. The Justice Department has defended its approach, with Deputy Attorney General Todd Blanche stating at the press conference that the department was always concerned about the victims and that President Trump had directed the Justice Department to be as transparent as we can. However, transparency and victim protection are not mutually exclusive goals. Other sensitive document releases have managed to provide public accountability while redacting identifying information about victims. The failure to do so here suggests either incompetence or indifference to the consequences for survivors. Beyond Trump, the files contain references to numerous other prominent figures across politics, business, entertainment, and international affairs. Former President Bill Clinton appears in multiple contexts, including photographs and correspondence. Clinton has acknowledged knowing Epstein socially, but has denied any knowledge of or participation in criminal activity. Britain's Prince Andrew appears extensively with witness statements describing allegations that have been publicly known for years. Andrew, who was stripped of his military titles and royal patronages, reached an out-of-court settlement with Virginia Giuffre, who alleged she was trafficked to him as a teenager. The settlement included no admission of liability. Billionaire Elon Musk also appears in the files. Emails show that Musk coordinated with Epstein about trips to one of Epstein's Caribbean islands, contradicting Musk's previous claims that he had rebuffed Epstein's attempts to get him to visit. Commerce Secretary Howard Lutnick's family accepted an invitation to visit Epstein's private island for lunch in December 2012, according to documents. Kevin Warsh, nominated to be the next Federal Reserve chairman, appears on a list for a gathering at Epstein's St. Barth's property in 2010, though it is unknown whether he attended. Being mentioned in connection with Epstein has become politically and professionally toxic, even for individuals who have not been accused of wrongdoing. The mere association carries reputational risk in a way that few other scandals do, because the nature of Epstein's crimes, the systematic sexual abuse of vulnerable young women over decades, is so morally repugnant that proximity to him suggests, at minimum, a failure of judgment. Yet there is a difference between appearing in Epstein's orbit and participating in or enabling his crimes. The files show that Epstein collected information about countless prominent individuals, maintained extensive correspondence, and cultivated relationships with people across industries and continents. Some of these relationships were undoubtedly innocent. Some involved people who may have suspected Epstein's misconduct but looked the other way. Some may have involved individuals who actively participated in or enabled his crimes. The challenge is determining which category any particular individual falls into. Congressional frustration with the Justice Department's handling of the release has been bipartisan. Representative Ro Khanna, a California Democrat who co-authored the legislation requiring the files release, stated publicly that the Justice Department has released at best half the documents it is supposed to under the law. Members of Congress from both parties have complained about heavy redactions that make it impossible to assess the significance of many documents. Some lawmakers who viewed supposedly unredacted files in a secure Department of Justice facility reported that the documents they sought remained redacted even in that supposedly transparent review process. The redactions have become a particular point of contention. Survivors advocates and a watchdog organization have complained that the files appear to be missing communications between top Trump administration officials and that certain names appear to be protected while others are exposed. One group of survivors described the redactions as abnormal and extreme. The Justice Department has cited privacy concerns for victims and unindicted third parties as justification for redactions, but critics argue the pattern of what is redacted and what is not suggests selective protection of powerful individuals. The fundamental question that emerges from all of this is whether justice is possible when the accused and the investigators exist in the same sphere of power. Jeffrey Epstein cultivated relationships with presidents, princes, billionaires, and influential figures across industries. His operation succeeded in part because powerful people either enabled it, ignored it, or benefited from the access and influence it provided. Now, years after his death, the same institutions he potentially compromised are responsible for investigating his crimes and holding his associates accountable. Deputy Attorney General Todd Blanche, who made the announcement about the file release, is himself a figure with close ties to President Trump. Blanche previously served as one of Trump's defense attorneys before being appointed to his current position. Attorney General Pam Bondi, who leads the Justice Department, was notably absent from the press conference announcing the release, an absence that raised questions given the significance of the disclosure. Bondi has made multiple statements about the Epstein files that were later contradicted by the actual content of the documents, fueling suspicions that the Justice Department under the current administration is not approaching this matter with the neutrality that justice requires. The Epstein case has become, in many ways, a test of whether American institutions can function as intended when those institutions are led by individuals who appear in the very files they are charged with investigating. It is a test of whether transparency is real or performative, whether redactions protect victims or perpetrators, whether unverified allegations are treated as meaningless noise or as leads that deserve serious investigation regardless of who they implicate. More than 1,500 survivors of Epstein's crimes have been identified since investigations began in the mid-2000s. Each of these individuals has a story of exploitation, manipulation, and betrayal. Many were teenagers when they were first drawn into Epstein's orbit. Some were promised modeling opportunities, dance instruction, or massage work that turned into something entirely different. Others were recruited by women working for Epstein, including Ghislaine Maxwell, who has been convicted of her role in this enterprise and is now in prison. For these survivors, the document release represents both an opportunity and a fresh trauma. It is an opportunity because transparency about what happened, who enabled it, and how law enforcement responded may finally provide some measure of accountability and closure. It is a trauma because their identities have been exposed, their privacy violated, and their experiences sensationalized in media coverage and social media speculation. They have been forced to relive their abuse in public while watching powerful men debate whether they are credible, whether their allegations matter, and whether anyone will face consequences for what was done to them. The question that lingers is this: are these files the beginning of a genuine reckoning, or are they the final chapter in a cover-up that uses the appearance of transparency to avoid real accountability? Will anyone besides Epstein and Maxwell face criminal charges? Will those who enabled the operation, who provided the money and resources and access that made it possible, face consequences? Will law enforcement officials who failed to investigate credible leads be held accountable for those failures? Or will this document release be remembered as 3 million pages of obfuscation, a mountain of paper that buried the truth rather than revealing it? The answers to these questions matter far beyond the individuals named in the files. They matter because they will tell us something fundamental about the society we live in. They will tell us whether power truly does shield people from accountability, whether survivors are worth protecting as much as reputations, whether institutions can be trusted to police their own, and whether the promise of equal justice under law is real or merely rhetorical. What happens next is not predetermined. Congressional investigations continue. Advocacy organizations are analyzing the files and demanding answers. Survivors are speaking out despite the risks. Journalists are sifting through millions of pages looking for patterns and connections that might have been missed or deliberately obscured. The public is paying attention in a way that makes it harder for institutions to simply move on and hope the scrutiny fades. But attention alone is not enough. What is needed now is sustained pressure for complete transparency, for answers to specific questions about who knew what and when, for explanations of why certain leads were pursued while others were ignored, and for consequences that extend beyond the two people who have already been convicted. The Epstein case is not just about Jeffrey Epstein. It is about the network that enabled him, the institutions that failed to stop him, and the systems of power and influence that allowed a predator to operate openly for decades. These files exist because Congress forced their release. That should not have been necessary. A functioning Justice Department should want to provide transparency about its own investigations, especially when serious questions exist about whether those investigations were thorough and impartial. The fact that transparency had to be mandated by law, that even after being mandated it arrived late and heavily redacted, and that survivors were harmed in the process suggests an institution more concerned with protecting its reputation than serving justice. The public deserves better. Survivors deserve better. The principle of accountability demands better. Whether we get better depends on whether enough people continue to demand it, whether enough members of Congress from both parties continue to press for answers, and whether the media continues to investigate rather than simply report what officials claim. The Epstein files are not just documents. They are evidence of what happened, records of who knew, and a test of whether our institutions will choose accountability over protection of the powerful. The questions these files raise deserve answers. The survivors whose lives were destroyed deserve justice, and the public deserves to know whether the people in positions of power can be trusted to deliver both.